My name is Douglas Elliott. I'm a gay activist, and I was the lawyer for the Metropolitan Community Church of Toronto in the same-sex marriage case. Well, the M&H case was foundational to the struggle for equal marriage. In Canada, going back to the 60s, actually, with the Canada Pension Plan Act, we've had legal recognition of what we call common law couples. It's a Canadian term, actually. It's called de facto couples in a lot of other countries, people who live together for a long period of time and who are considered to be similar to man and wife. So we have widespread recognition, particularly in Ontario, thanks to the Family Law Reform Act introduced by then Attorney General McMurtry in 1978. We've had widespread recognition of common law couples. But same-sex couples did not have the same rights and obligations as common law heterosexual couples. And people in the LGBT rights movement felt very strongly that we could never get, and I was one of them, we could never get to marriage unless we got common law recognition. Because of course the problem with marriage was the religious objection, and there was no religious recognition of common law relationships. In fact, when I was a kid growing up in Elliott Lake, we referred to it as living in sin. It was the opposite of having the recognition of the church. So we felt if we couldn't get that legal recognition, there was no way we could get to marriage. And so there actually were some early attempts at marriage cases, one in Ontario in particular, that were discouraged deliberately. American activists like Evan Wolfson were discouraged from encouraging a marriage case in Ontario until we had a good case on common law recognition. Along comes M versus H, and a very young but very talented young lawyer named Martha McCarthy, who was hired by M to seek spousal support from her wealthy partner H. M was penniless. And this was a huge challenge for Martha. She was, I think, a second-year lawyer at the time. And she took the case on and was successful in front of Madam Justice Epstein at the trial court level. It went to the Court of Appeal, and it was at this point that the LGBT community pricked up their ears and intervened, and I represented the Foundation for Equal Families, a prominent Ontario LGBT charity headed by iconic activist Michelle Douglas, who had fought to end the ban on gays in the military. The Court of Appeal ruled in a divided decision that common law couples were entitled to legal recognition. At the same time, this case went to the Supreme Court of Canada. Another case called Vreen versus Alberta was going to the Supreme Court of Canada, where the Alberta Court of Appeal had said that Alberta did not have to have sexual orientation protection in its human rights laws. So we had two different courts of appeal with two different views, both heading to the Supreme Court at the same time, which one was going to prevail. And for couples, for same-sex couples, the M versus H case was really where the money was. And the Supreme Court of Canada, in an 8-to-1 ruling, said that common law couples' rights and obligations had to be extended to same-sex couples. And it really was the great leap forward, especially because the Supreme Court said that LGBT people should not have to keep suing the government to get their rights, that the governments should take their responsibilities under the Charter seriously and take action to correct these discriminatory laws. So we saw in a number of jurisdictions, but particularly in Ontario and at the federal level, omnibus legislation. In the case of Canada, 68 laws were updated to include common law recognition for same-sex couples. There was a lot of game playing about nomenclature and so on, but it did have a huge impact on equality. M versus H was the great leap forward, and a lot of people forget about it today because it sort of got overshadowed by marriage, which was the brass ring of equality, but M versus H and the really powerful decision written by Justices Corey and Iacobucci, that really propelled us almost to marriage. They said in the decision, we're not deciding marriage. Yes, Modernization of Benefits and Obligations Act is what the bill ends up being called, known as MOBA to some of us, even though it's actually MBOA. And it was Bill C-23 when it was on its way through Parliament. And that was a response to M versus H. Mike Harris did it in a more grudging way. His act was called an act to comply with the Supreme Court ruling in M versus H Act. I said he should have just called it the Devil Made Me Do It Act. But Anne McClellan, the Justice Minister at the time, was a constitutional scholar, former dean of University of Alberta Law School, but a fairly conservative liberal. She recognized that the laws had to be changed, and so she introduced this omnibus bill, but it did have a couple of poison pills built into it. It has been observed by a number of scholars, but I know from personal experience that what was going on at that time was that the liberal governments, when they were in power, were inclined to advance LGBT rights, but they lacked the political courage to do it. In fact, I had a meeting with Alan Rock when he was the Minister of Justice, and I said, Alan, do I have to keep suing you? And he said, yes, please. It gives me so much help with my caucus when I can go to them and tell them that the courts have required us to do this. He said, when I became Minister of Justice, I thought I could change the Human Rights Act easily because it's obvious to us lawyers, Douglas, but it's not so obvious to some of my caucus colleagues who are truly homophobic. And that is what was going on. And so the politicians, when the Liberals were in power, the politicians were cautious. They were behind the courts and they were behind the population. But the Liberals were very devoted to the Charter. They had created it. And they were particularly opposed to the use of Section 33, the notwithstanding clause. They had made a solemn pledge that they would never use it. Pierre Trudeau held his nose when he agreed to create it. And so we always felt that if we were suing the Liberals, we didn't have to fear Section 33. When we were suing conservative governments, it was a different matter. When we were involved in the Vreen case, I was convinced Ralph Klein would use Section 33 to overturn it, and he didn't. He said that he thought discrimination against homosexuals was morally wrong when it was suggested he invoke Section 33, much to my shock. But by the time the Conservatives took power at the federal level under Prime Minister Harper, well, we had the Mulroney era and then we had the Harper era. Mr. Mulroney was a true progressive conservative. It was the Progressive Conservative Party at that time. And if you look at his memoirs, when Michelle Douglas's fight was going on, he accepted the court ruling and he told his caucus to suck it up. That he said famously in a caucus meeting that he believed that the Conservative Party reflected the Canadian people and that 10% of the population was gay. That meant 10% of his caucus was gay, and he was not going to tolerate discrimination against anyone in his own caucus. So that Mr. Mulroney followed the same path that the Liberals had followed in allowing the courts to lead his government by the nose, doing things that he perhaps personally would like to have done, but didn't have the support of his caucus without the backing of a court ruling. When Mr. Harper came along, it was a different matter. But by the time Mr. Harper took power, and by the way, Mr. Harper is the only Prime Minister of Canada to ever have been a plaintiff in a charter case, Harper versus Canada, challenging restrictions on election spending, a case he lost. Perhaps his bitterness over that defeat is why he's been so hostile to judges and the Charter of Rights ever since. But even he realized by the time he was running for election in the wake of the Supreme Court's decision on same-sex marriage that invoking Section 33 was not going to be popular with Canadians. And so as a number of people had predicted, such as Attorney General McMurtry, Section 33 became an atomic bomb in Canadian politics. It was something that was there and could be used, but no one dared to use it because the consequences would be so deadly. And so no government, except for the Quebec government to protect language laws, no government's ever used it, which really surprised me. Whenever we undertook any of this litigation, whether it was M versus H or the marriage litigation, we always feared that our victory would be snatched away. You know, I remember after M versus H talking to Jim Flaherty, a very conservative Catholic, about how they were going to respond. And I was afraid they were going to use Section 33, but he was a lawyer, and he accepted that the court was right, and whatever his religious views were, that he had to get over them. Of course, he was married to a woman named Christine Elliott, and so I think the Elliott influence on Mr. Flaherty was a positive one. By the time M versus H was argued, I had really gotten to know some of the key lawyers and activists around this issue. Martha McCarthy and I were very good friends. Evan Wolfson had become a friend, notwithstanding our initial clash over the timing of the challenge to marriage. And it began actually in the wake of M versus H. Martha said to me, maybe we can do a marriage challenge now. And I thought it might be possible. The government had even hesitated in Bill C-23. They had been pushed to include a definition of marriage, to try and freeze the definition of marriage, and they had used very cautious wording, and they said that the bill didn't affect the definition of marriage. So that assuaged the conservative opponents, but it didn't lock in the definition of marriage, and they clearly were not going to use Section 33. So we had a chance. There was a major conference on same-sex relationships held at the King's College in London, and Martha and I attended that, and there was a great debate about which country was going to be next, and how were we doing on a relationship recognition. Justice Laura Dubé was at that conference. She was an early proponent of recognition of same-sex relationships, and I remember her saying to me, Douglas, I think Canada is the best. That at that point, she felt we were leading the pack. There was no country that had same-sex marriage first, and the debate was who was going to get it first, America or the Netherlands. America through the courts, the Netherlands through political process. Canada didn't seem to be in the play to people until that conference. People started talking about Canada. And we talked to a bunch of our colleagues. One of the people there was Professor Kathy Leahy. She told us about a conference that was going to be held that fall. No, it was a little later that year, not the fall, and in Kingston. And we persuaded Evan Wolfson to come to that meeting, and on the train from Kingston to Toronto, we hatched the plot with Evan Wolfson. I've often thought that railway car should be preserved as a historical spot somewhere, but thanks to VIA, we had the opportunity to discuss our strategy, and we agreed that Martha was going to put together a group of couples who were going to pursue civil marriage, and I was going to approach the Metropolitan Community Church of Toronto about doing religious marriage, because Evan made it clear to us that the main opposition would come from religious groups. We'd have to be prepared to deal with that in the political and media realm, but that one of the best and most effective ways of dealing with that would be to have a church that was involved in the case, so that it wasn't, as Brent Hawkes says, every time it's about the gays versus God, the gays lose. So having a church there, I felt we could make some arguments about religious freedom, about how the, if you know the history of marriage in Ontario over the years, it used to be only Protestants could get married, and then it was only Christians, and then it was opened up to all religions, and then it wasn't until 1950 in Ontario, 1970 in Quebec, that you could get married outside of a religious institution at City Hall. So there is a whole history of marriage being used by the state to discriminate against minority religions, and I felt that that was something that would resonate with Canadians. And also I felt that in Ontario, since most people get married in a church or other religious institution, if you didn't have a connection with a religious institution, it wouldn't touch people's hearts. And Reverend Brent Hawkes was becoming a very well-known figure in Toronto and in Ontario, and indeed in Canada by this time. So shortly after that, we ended up starting our case prematurely because Michael Leshner, who had been told not to speak to the media by Martha, when he was refused his marriage license, immediately called a press conference and told Martha he was holding it. I was at the hairdressers at the time, I remember, and I had to rush down to be there. So he sort of forced our hand. Off we went to court, kind of half-cocked, but MCCT, Metropolitan Community Church of Toronto, became an intervener in that case brought by civil couples. So we're now into the year 2000 that our strategy has been smoked out by the Michaels. I mean, this is part of LGBT activism. You can't control activists. They do whatever they're going to do. And certainly Michael Leshner, it fits that bill to a great extent. He's a very strong personality and not to be managed, even by Martha McCarthy. So the sequence was spring of 1999, we have the conference in London, in England. Fall of 1999, we have the conference in Kingston. And then it's the spring of 2000. It was actually Victoria Day weekend, I remember. I was getting ready to go away. We decide to go ahead with the civil cases. I'm going to be an intervener as opposed to an applicant in the case. And the City of Toronto is supporting it. This was a big surprise. That's why Martha wanted to move then, because the City of Toronto said that they would not oppose the granting of the licenses, but would seek direction from the court. In the meantime, there were conferences going on to discuss where marriage should be pursued first. EGAL, the national organization, had decided to go in BC because they thought they could win in BC. And the BC government initially was an NDP government, was supportive. Well, by the time it got to trial, the BC NDP had been defeated by the Socreds and they reversed positions. Same thing had happened in Ontario with M versus H. Started off with supportive NDP government, flipped to the Conservatives, and they became hostile. And we had warned EGAL that might happen in BC, and it did. So we were confident Ontario was the best place to go. Kathy Leahy then gets in touch with me and says, Doug, do you know about the bans of marriage? And I said, well, I grew up as an Anglican. I have heard of them, but so what? And she said, well, did you know that, she said, isn't MCCT licensed, Metropolitan Community Church of Toronto? Aren't they licensed to perform marriages? I said, yes, recently. It took years for them to get that recognition, but yes, they can perform heterosexual marriages. Why? And she said, well, under the law, if they are a licensed church, they can use the publication of bans as a substitute for a license. And once they marry people, they're deemed to be legally married under the law, and they don't need a license, they don't need anything else. So you can actually have a wedding and then present that as a de facto marriage and defy the government to stop you. She said, no, I think the only way the government can prevent it is by yanking the license of the church. And I looked at it and I thought, this sounds too good to be true. It can't be that easy. I thought we had to fight for a license. I read everything and I was convinced that Kathy was right. So I went to Brent Hawkes, who also said to me, it can't be this easy. And I said, it won't be easy. But I said to Brent, look, the main risk is that the government, and it was the conservative government of Mike Harris then, not a friendly government to the LGBT community, and Bob Runciman, now Senator Runciman, particularly hostile to the LGBT community, was in charge of this issue. I said, you run the risk that they're going to pull the church's license, but I said, or they could seek an injunction to stop you from marrying these people, but I can't imagine they would do that because it would be political dynamite for them to be discriminating against a church, to be attacking a church, and a church that is known as a haven for LGBT people and a beacon of human rights. It would be really dangerous politically. So he agreed, he talked to the board, he talked to the straight people in the congregation who would be affected if we lost the license, and he said, go ahead and do it. Part of the process of the bans that was really thrilling and terrifying was that it required a public announcement in the church, and that Brent would have to allow people to object. So as luck would have it, the first day that we announced it has to be done 3 times at a public service at the church, and then you can proceed to the wedding. So the first day was International Human Rights Day, as it turns out, by coincidence, the day the UN Convention on Human Rights was signed. And we went there, my friend John McGrath was there from the CBC radio and did a beautiful story on it. And we did this announcement that we were doing the bans. Brent wanted to be very clear. He didn't want to sneak this through. He didn't want to do anything underhanded. He wanted to be very open with the government that we were doing it and let them decide whether they were going to try and stop us. And I think that was very brave and noble of him. And we were so shocked the first day. No one objected. I'll admit I had a tear in my eye. I was so surprised. And there was kind of a sharp intake of breath, and then this huge round of applause, thunderous applause. People were so happy that there was no objection. Then we got a letter from the government saying, stop, cease and desist. And this is an unlawful wedding that you're planning. But they didn't say what they would do if we went ahead. So I sent them a letter saying, what we're doing is protected by the Charter of Rights. We have no intention of stop us if you wish. We didn't hear anything further from them at that point. Second reading of the bans, there were objections. And I've got to say, as somebody who belonged to that church, it was really hard to hear anti-gay religious propaganda being spouted in our church. For your viewers, I can only say it would be like listening to someone from the Ku Klux Klan speaking at a primarily black congregation, or a Nazi speaking at a synagogue. It just cut like a knife. But we had to listen. It was the law. And fortunately, I had explained to Brent that the person who decided whether the objection was valid or not was the presiding officiant, namely him. He was so excited to hear that. And I said, you have to decide whether the objection is legally valid. And I said, so for example, if someone says, our two couples, Kevin Barassa and Joe Varnell, and Elaine and Anne Vautour, I said, if someone stands up and said they're not old enough to get married, or they're already married to someone else, those are valid legal objections and you have to accept them. But if, as we expect, someone stands up and says this is against God's ordinance, you are entitled to say that that's not a valid legal objection if you don't believe it is. And he said, well, I don't believe it is. Do you? And I said, no, I don't believe it is either. So he said, fine. So after the people objected, and one of them was Ken Campbell, who is a longtime anti-gay. He brought Anita Bryant to Canada. Ken Campbell was probably the most despised homophobe in the country, and there he was in our church. And he left after he spewed his vitriol. The third reading of the bans, we were bracing for it, and there were two people who objected. But I will say that the two people who objected the next time, they weren't famous people like Ken Campbell. He didn't come back. And they were much more gentle in what they said. They voiced a religious objection, but it was done in a more respectful way. And Brent invited them to stay and worship with us, and they did. So I felt that their objections were more respectful and sincere. Brent nonetheless ruled against them and said that the marriages would proceed on January the 14th as planned of 2001. And there was again a thunderous round of applause, and I was in a bit of a state of shock that it looked like this was actually going to happen. January 14th, 2001, a day I shall never forget, and I hope Canadians will never forget. It was a Sunday, unusual for Christians to get married on a Sunday, but that's how it worked out. I remember going to church that day in the morning for the church service, and I was with a couple of my colleagues who were LGBT activists who didn't have a very favorable opinion of churches, to put it mildly. Like a lot of LGBT folks, they had had bad experiences. And we came along, and there were mounted police. There were a lot of police. There were protesters wearing devil masks and with homophobic slogans on them. But interestingly, one of my colleagues, her first reaction was, why are there police? I don't like seeing the police there. And I told her that some years previous that a Metropolitan Community Church in Atlanta had been attacked by homophobes. They had barricaded everyone in the church and then thrown Molotov cocktails inside, and the entire congregation and pastor had died in the flames. And I said, we can't take any chances. And in fact, there had been a bomb threat. There had been death threats against Brent Hawks, our pastor. He was wearing a bulletproof vest. There were, the police tactical squad was secreted away in the basement of the church. We had used high security to get the couples there that day, and Brent. Brent didn't think he was going to live out the day. He's admitted that since. He called his family and said that he loved them and that they might not hear from him again. And during the service, at a certain point in the service, we were about to sing a hymn, and I looked up, and here was this woman at the front of the church in a trench coat, or like a heavy coat, and most people take their coats off when they get into the church. So I thought, why is she wearing a coat? What's under the coat? And she started screaming about homosexuality as a sin. And Brent came over to her to try and get her to be quiet, and she shoved him out of the way. And then she reached into her coat, and my heart stopped, and then she threw these pamphlets up into the air. And then she was hustled out by the security. I was afraid she had a bomb or a grenade or something, a gun, something. So it was a terrifying moment, and she was later convicted of assault. But things sort of, we sang really loudly and things slowly calmed down. And then there was a pause, and then we got ready for the wedding, which took place at 2 o'clock in the afternoon. So just, there was a short interval between the church service and the weddings. I've never seen anything like it. The front of the church was filled, on the right-hand side, was filled with cameras from all over the world, including from the Christian Broadcasting Network from the United States, not one of our friends. It was world-beating news that this marriage was taking place, because if it was legal, it was going to be the first legal same-sex wedding in the world. We were all really, really conscious of the fact that this was an historical moment. It's not very often that you know that when you're at an everyday event. I mean, it's one thing to be sworn in as prime minister or president or whatever, or crowned queen, but for an everyday event like a wedding to have historical significance, and you know it when it's happening that it's going to have historical significance, it's overwhelming. It was extremely powerful. I was electrified, and I think that's true of all of the people who were present. And there was also a great sense of excitement and joy, great joy. We knew you could see these two couples, they'd already been through holy unions. Anne Vautour had changed her name, even took her partner's name. They clearly loved each other. They were young, attractive couples, very photogenic, very articulate, and very courageous. We knew that they were, most gay people up until then, most of us lived our lives in the closet. We didn't want people to know that we were gay. Our families didn't want, even if we came out to our families didn't want the neighbors to know. My mother-in-law was like that, She was accepting of me, but she didn't want her friends to know about her son. She got over that with time, but that's where she came from originally.
And all of a sudden, here are these two
They're
couples sitting there.
There's nothing, you're not just out to their families, they're out to the entire world. They're out to the entire world and proclaiming that they love each other and want to live in that love together for the rest of their lives, and clearly very sincerely believe that. And for me, given that the Christian church has been the foundation of most of the oppression of LGBT people in the Western world, it was so powerful that that wedding was taking place in a Christian church, not in defiance of Christianity, but in a Christian church using the most ancient Christian tradition of marriage, the bands of marriage, to create that bond that was going to be legally binding. And for me as a lawyer, to think, okay, with the help of Kathy Leahy, I cooked up this strategy, and I'm watching it unfold before my very eyes, and it's working. And the people were so happy. The wedding was so beautiful. The tenderness between the couples, the gentle intimacy of putting the ring on, the spirituality of the moment. It was absolutely incredible, beautiful. And I thought, no one can see this and hate it. No one can see this and hate it. And I had thought about that just a week before the weddings. I had driven by on Bloor Street, St. Paul's Church, and there was something going on, and I looked over, and there was a married couple coming out, and I smiled. It was an automatic reaction, and I thought, that's how people react to a wedding. That's how people are going to react to this wedding. I believe it in my heart. It doesn't matter that it's same-sex couples, it's still a wedding. And when they see it, it's going to defang same-sex marriage. You know, going back to my mentor, George Hislop, told me the most powerful political statement that any gay activist can make is to come out. It's visibility. Visibility is our greatest weapon. Invisibility is the cornerstone of our oppression. And what more visible way to say same-sex marriages are real marriages. They're not pretend marriages. They're real marriages. They're just like anyone else's marriage. They're in a church with family and friends and happiness and cake and presents and all of those great things that we love about weddings. And I realized that joy that we were feeling at that moment, that's what our opponents wanted to deny us. They wanted us to be miserable. They didn't want us to have happiness. And that's why we were fighting for equality in the case of same-sex marriage. When Brent presented those couples, you've seen that image, I'm sure, many times, presenting the two couples, and he said that they were married under the laws of our land. Wow, I was in tears, because he was proclaiming to the world this was a legal same-sex marriage. It wasn't just a private ritual or ceremony. It was a legal marriage. We were taking a stand. The signing of the registry, all of that stuff was done perfectly legally. And in fact, I was presented with a picture of Brent signing the register that I still have in my office. And that was one of the most magical days in my legal career, for sure. One of the most magical days in my life, only topped by my own marriage, I think. But that was the beginning of the fight. It wasn't the end. And I will tell you, the media were extremely important to us. The media gave nothing but positive coverage of that event, and the widespread coverage it got had a tremendous impact. A very respected pollster told Brent Hawkes that we went from 45% of Canadians supporting same-sex marriage to 55% because of that event. It tipped the balance in favor of same-sex marriage. It's partly because of the legal strategy, partly because of the couples, but the media played a tremendous role. It shows how important the media are in a free and democratic society. We made it very clear that as far as we were concerned, it was a legal marriage. I knew the legal requirements, and the legal requirements had been fulfilled. It was a legal marriage from that moment. However, under the Vital Statistics Act, the church was required to submit the marriage documents for registration with the Ontario government, and the Ontario government was required to deposit them and to make them public, and then issue an official Ontario marriage certificate to the couples if they required it as a proof of their marriage. It did not make their marriage legally valid. It was just proof that it was legally valid. So I told Brent, I think we need to submit these documents to the Ontario government, and Bob Runciman was the minister responsible at the time, and he said, I will not accept these for registration under any circumstances. And so we went to court. We held a press conference about it at my law firm, and we announced that we would be taking the Ontario government to court and that we would be joining our case with the case of the civil couples. So we were still an intervener in the civil couples case, but we were now applicants, and we now had our own case that was driven by the church. And that was very important, because when you have your own case, you can control the evidence, you can make the arguments in a much more powerful way than if you're just an intervener. So, but really the great advantage we had that no one had had anywhere in the world who had tried to get same-sex marriage was we had married couples. We had a fait accompli that we were presenting to the courts. We were saying, look, these people are married, the government won't recognize it, why not? And it sort of pushed the onus back onto the government to explain. So we started off in the divisional court, and what we were really seeking was an order against Bob Runciman, forcing him to register those marriages, and forcing the federal government to recognize that same-sex couples were entitled to be married. Now, by the time we got to the divisional court, the ruling had come down in British Columbia, which said that it would require a constitutional amendment to permit same-sex marriage. It was devastating. We were terrified by this BC decision. And so we really felt that the momentum that we had gained by the wedding had been lost to a certain extent by having this devastating ruling from Justice Pitfield in a case that unfortunately bore the name of Egal versus Canada, poor Egal. Great organization, but they had made a bad choice by proceeding in British Columbia first. So we ended up in the divisional court in front of a 3-judge panel, Chief Justice Smith of the Superior Court, Justice Blair, and Justice Laforme, the only Indigenous judge. And I was so happy to have him there, because a lot of Canadians don't realize that prior to Europeans arriving in this country, there used to be same-sex marriage recognized by First Nations people. Sitting Bull had a same-sex partner, a bunch of female partners as well, but he had a same-sex partner. Indigenous people didn't care about these. They respected what they called two-spirit people. So when we were in the divisional court and the other side was talking about tradition, I could say, traditional for whom? Traditional for Europeans, not traditional for Canadians. The Canadians who were here for thousands of years before Europeans arrived, they recognized same-sex marriage. It was Christianity that refused to recognize same-sex couples, and now the law is enforcing the Christian religion, a particular brand of the Christian religion, on people who don't follow that. It's the same old religious discrimination we've always faced. And it's sexual orientation discrimination. And it was a really amazing argument. I thought it was extremely powerful. We had the right bench for it. Justice Blair was a little bit cautious compared to the other judges, but he clearly thought that the arguments that were being made by the government about this would be the end of marriage and the end of civilization were nonsense. And I got to use the great line from my father, who was a police officer and always coached me on my cases, and they were relying mainly on procreation, that, you know, marriage was all about procreation and same-sex couples couldn't procreate. And so I said, according to a leading authority on heterosexual marriage, my father, marriage is not about procreation, it's about recreation. Well, all of the judges burst out laughing, and that mockery really put paid to the procreation argument as far as I'm concerned. My colleague Trent Morris dealt with the British Columbia decision in a masterful way and really eviscerated and showed how ridiculous the idea was that the definition of marriage was somehow frozen in 1867. It clearly wasn't. Marriage has evolved over the years in Canada. You know, it used to be the hallmark of Christian marriage, and that's what 1866 ruling says. In Christendom, marriage is the union for life of a man and a woman. Well,
for life we got rid of with divorce, right? And in Christendom, are you kidding me? And in modern Canada, that we're taking a Christian definition and imposing it on the rest of the population. And it's not even a definition as we made out. It's not a definition accepted by all Christians anymore. You know, not only our church, but other people were willing to perform same-sex marriages if the state would allow it. And I felt that we made a very good case for saying, as I said, that if you look around Osgoode Hall, you see these paintings of judges from the 19th century, from the time that definition was handed down. They're all old white guys. That's not the definition of a judge. That's the Victorian image of a judge. We know that you don't have to be white or to be a man to be a judge. You have to be wise and just and courageous to be a judge. But that's the 19th century idea of a judge. Just like this definition was the 19th century idea of a marriage. We're not living in the 19th century anymore. And a judge today has the power. If a judge in the 19th century could create that definition, a judge in the 21st century could change that definition. And we got the ruling, and I remember it well. They gave it to us an hour in advance before the media. It was a long decision. Each of the judges wrote separate rulings, so that you know, for us lawyers, when you see 3 separate decisions, it's like, oh my God, what does this mean? You've got to just sort of figure out, piece it together, what's the majority ruling? And it wasn't that clear to us, but ultimately, as I read each one, it dawned on me that the collective decision was, we won. And I looked up at Kevin and Joe and Brent, and I was shaking, and I said, we won, we won. And they were ecstatic. Everyone was ecstatic. Now, so BC was history. We had the momentum. Now, the only drawback was that 2 of the 3 judges said that perhaps there was an alternative to marriage, and they were going to give Parliament 2 years to figure out an alternative, which was the longest time that Parliament had ever been given, to my knowledge, by a court to fix a constitutional problem. And so our marriages were not recognized by 2 of the 3 judges. The 3rd judge, Justice Laforme, would have recognized it, which he will always be my hero for having made that ruling. And surprise, surprise, it's the Indigenous judge that reaches that conclusion, right? Shows the need for diversity on our bench. So we knew that there was going to be an appeal. To our surprise, the Ontario government decided not to appeal. Only the Canadian government appealed. The Ontario government, I think they could tell that the political tide was turning, that the public, this was a huge social debate while this was going on. Everywhere you went, everybody was talking about it, everyone. I remember getting into a cab, and there was an Orthodox Sikh driving me, and he's listening to talk radio, and he asks, you know, what I was doing at this TV station, and I said I was talking about same-sex marriage, and he said, which side are you on? And I said, well, I'm representing the church where the couples were married. And he said, when I get home, I shall tell my family that I had the honor to have you in my cab today, sir. This is what makes Canada a great country. And I thought, how fantastic. Like, I was afraid the guy was going to throw me out of his car, and instead, to him, even though it might be against his religious beliefs, he got it, that it was about human rights. So off we went to the Court of Appeal. Court of Appeal, we knew our panel was going to be a very strong panel. Justice McPherson, who used to be a dean, Justice Galees, who used to be a dean, and Chief Justice McMurtry, one of the authors of the Charter of Rights. You couldn't have a stronger panel, really. But of course, Brent Hawkes was horrified when he heard out that Chief Justice McMurtry was going to be presiding, because back in the days of the bathhouse raids, Roy McMurtry was the Attorney General. He had been blamed for the bathhouse raids. Brent had gone on a hunger strike to protest them. If I had told him Satan was going to be presiding over the decision, he couldn't have been more disturbed. But I managed to persuade him that I thought things would turn out all right. And as it turned out, they turned out very well indeed. I mean, the Court of Appeal hearing, the argument went extremely well. I should say one of the really amusing parts of this story is that even though we were said to be against the family, that in both the divisional court and in the Court of Appeal, a member of our legal team was visibly pregnant. Martha McCarthy was pregnant in the divisional court, and her colleague Joanna Radbourne was visibly pregnant, a lesbian, was visibly pregnant during the Court of Appeal hearing. So the argument that we were opposed to procreation was kind of not really working, I don't think. It was very clear to me from the get-go that the Court of Appeal had formed a view that the divisional court was right about the definition violating the Charter of Rights. But it wasn't clear what they were going to do about remedy. Were they going to leave the 2-year situation in place or not? So they were very interested in all the arguments about, was there an alternative to marriage? Did Parliament have another option? And of course, our team argued that there was no other option, that only marriage is marriage. That's what the whole fight is about. You know, as I said, when it's about symbolism. When Rosa Parks was sent to the back of the bus, it wasn't because the seats were worse back there or that it was going to take her longer to get to wherever she was going. It was the symbolism of sitting in an area that was designated for colored people, as they were called then, and not in the area that was reserved for white people. In fact, if you know the history well, they had a little sign that hung from the roof, and they'd move it back and forth depending on how many people were there. So it was actually exactly the same seats. It was just a way of designating people of a different race as inferior. That's all it was about. And we said that's what excluding us from marriage is all about. It's about designating us as inferior human beings. That's why they want to try and give us something else. You might as well put the pink triangle on us again like the Nazis did. That's what it is about. It's about gay relationships are not the same as straight relationships. It was the most wonderful moment, though, when I really knew we had won, was young Joanna Radbourne. She was young then, very pregnant, standing up, and Justice McPherson said, you know, by this time, the Netherlands had enacted same-sex marriage through their parliament. And Justice McPherson said to Joanna, well, if we rule in your favor, Canada will be the first country where the judges have directed that same-sex marriage will be lawful, as opposed to leaving it to Parliament. Why should we do that? And Joanna said, because that's what makes Canada a great country. And I said, there's no way they can rule against us now, because then they're saying that Canada's not such a great country. And of course, on June the 10th of 2003, we got the decision, and we won. Unanimously this time. It was a unanimous decision. None of the judges put their name on it. It was the court's decision. So we don't even know who wrote it for sure. So they all completely agreed, as opposed to the divisional court. And to our great surprise, they said, effective immediately. Now, Martha and the Michaels had been ready for that possibility. And they had a judge lined up who was a friend of Michael's, and off they rushed, armed with this ruling, got their license, and got married by a judge. And people started getting married in droves. It was almost like a marriage panic because people were afraid there was going to be an appeal, that it was going to get overturned. Some people will recall that's what happened in California, that some people got married and then they stopped it for a while and people couldn't get married. And so people were really worried about that. And especially longtime partners like Kyle Ray, the city councilor, and his partner ran out and got married right away because they were afraid something bad was going to be happening. But interestingly, we had been fighting, Martin Cochon was the Attorney General, and his troops had been fighting us very vigorously. There were accusations that they hadn't been, but let me tell you, I was in the courtroom. They were giving it all they had. Rosalind Levine, who was leading the charge for the Department of Justice, not a homophobic woman, by the way, but a very powerful advocate, and she was determined to put the best arguments forward she could. She was determined to try and win if she could, fairly, but she was determined to try and win. And you know, there were stories spread by the right that, you know, Jean Chrétien had called up Roy McMurtry and told him to rule that way and so on. Just nonsense. It doesn't happen in our democracy. But what did happen is that in North Bay, the Liberals were having a caucus and they had a discussion about what to do about the Court of Appeals ruling. And Martin Cochon made a pitch to his caucus that they should not appeal. And they had a big discussion, and there were a couple of people who were openly gay, like Senator Lapierre, who I gather gave a very powerful speech about his life as a gay man. And at the end, Jean Chrétien said, very similar to Brian Mulroney had done with the military case, well, the courts have spoken, we're Liberals, we have to go by the charter, we're not going to appeal. Now, that was hard for Jean Chrétien personally. He was not that supportive of LGBT rights. And in fact, apparently, I've been told by Roy McMurtry that Chrétien, now one of his favorite stories is he likes to tell people, I make McMurtry the Chief Justice, and what does he do? He gives me the same-sex marriage. So he wasn't that thrilled about it, but he had been involved in the creation of the Charter of Rights, and he believed in it, heart and soul. We got a tremendous boost later that month when the Vatican weighed in really heavily against us. And Bishop Henry of Calgary said that the Prime Minister was going to go to hell if, as a Catholic, he didn't oppose same-sex marriage. And Chrétien comes from a long line of Liberals who have fought with the Catholic hierarchy. And he said, when I'm the Prime Minister of Canada, I am there to defend Canadians and the Charter of Rights. And what I do in church is between me and God, and I'm not going to take orders from a bishop. That really cemented the Liberal support for our position, the Catholic Church opposition. They also stirred up the ethnic populations, the Chinese, and got them to come out, and we got the Liberal Chinese to come out and support us. The Chinese Canadian National Council came out, Avi Go came out and spoke in support of us. So we had the ethnic card, the race card played against us, in addition to having the Catholic Church say that it was opposed. But you know, they overplayed their hand, as I say, saying they were refusing communion to MPs. And they issued this document, and in it, I mean, I remember debating the president of the Canadian Conference of Catholic Bishops, and I said, you know, Canadians need to know what this document says. It says that same-sex marriage is the legalization of evil. I don't think Canadians believe that. I don't think Canadian Catholics believe that. But that's what the Vatican says. And the interviewer said, well, the bishop never said that. I said, I didn't say he said it. The Vatican said it. And if I'm wrong, let him correct me. And he said, well, you know, we have to put these things in a Canadian context. And she was horrified. Most Canadians were horrified. This isn't the way Canadians think. This is not the way we think. So we kept rising and rising in the polls, more and more and more support. The Catholic bishops actually tried to appeal the decision themselves. They went in front of a 3-judge panel of the Supreme Court of Canada, presided over by Chief Justice Lemaire, trying to get the right to appeal the McMurtry ruling because the government wasn't doing it, and they got thrown out on their ear. But we had to go and fight them on that too. So then we get a change in leadership. They asked 4 questions. Originally there were going to be 3, and then they added a 4th. So what happened is we had Chrétien and Cochon as the team that had originally fought us, then and I always felt Chrétien was leaning towards, in his heart, opposing us, whereas Cochon was leaning in his heart to supporting us. But once we got the Court of Appeal decision, they both supported us. That was the end of that tension. But then Martin took over as Prime Minister, and Kotler became the Attorney General, well-known human rights expert. And Kotler got it in his head initially that civil unions were an option. Well, I thought he was dead wrong. They can only be created by the provinces, not by the federal government. The federal government only has control of marriage, not anything else. So they decided, there was a lot of criticism from Stephen Harper about the fact that the Chrétien government had never taken the case to the Supreme Court of Canada. So in order to try and meet that concern, the Martin government agreed to have a reference to the Supreme Court of Canada, basically asking their opinion. And they were asking their opinion as to whether or not the proposed law that would allow same-sex marriage in Canada was constitutional. That was the essence of the case. They also asked a question that was very important to me, which was, could the provinces effectively opt out of this ruling? Because Alberta had said that that's what it planned to do. And then the final question that got added was the Halpern ruling, the McMurtry ruling, valid? Was the old definition unconstitutional? Well, some people thought we in the LGBT community wanted that question added, but we didn't. We already had a ruling that said we won. We didn't want to reopen that question. And we told the Supreme Court of Canada, don't answer that question, because if you answered the question, yes, it was unconstitutional, it doesn't add anything, but if you answer the question no, then it's going to create chaos, because it's just an opinion. And it's going to cast doubt on all of these rulings that are binding. So it's a legal mess. Don't touch it. And so those are the questions that they lined up. It was the most strange and amazing hearing I've ever been at. The Supreme Court of Canada was packed. They turned the lobby into a media studio. I've never seen that before. They had little panels of pundits set up in the lobby of the Supreme Court building. I've never seen anything like it. And of course there was, I don't forget how many parties there were, dozens and dozens of parties were allowed to participate in the hearing. Anybody who asked practically was allowed. Individual senators were sticking their oar in. It was a very huge cast of characters. And the Supreme Court of Canada, we had Dean Hogg, Peter Hogg, who was leading the federal team, and the federal government was now on our side. So things had changed from all the other hearings. They'd been fighting us. For the first time, they were on our side. And we had Dean Hogg. What more could you ask for? And I thought that this is going to be a breeze. And he stood up and he was roasted by the bench, not so much about the bill, but really about the fact that the Attorney General the week before had said that he was going to proceed with the bill regardless of what the Supreme Court had to say, and they didn't care for that. They felt they were being politically manipulated, which may or may not be true, but I think that's true of any reference. It is a political move. It's an attempt by the government to not rely on its own lawyers, but to get the 9 greatest minds in the country to say that this is legally valid. So it is political cover for the government in a way, certainly legal cover for them. So it was a great hearing, and I could never forget that it went faster. They had allotted 2 days, and we were done in a day and a half. I couldn't believe how quickly it went. And indeed, Dean Hogg stood up at the end, and he said, look, we're about done. I was supposed to have 15 minutes. Will you give me a half an hour? And the Chief Justice said, well, we'll give you 20. I was shocked at how quickly everything moved, but they'd obviously thought about this a great deal. And I was feeling pretty positive coming out of that. I felt that, you know, they were not buying the arguments that were being made against the bill by the huge number of religious opponents who, again, were saying it was the end of civilization and God was going to rain down brimstone on Ottawa like Sodom and Gomorrah, and it was the end of everything. They just weren't buying it. And I remember in particular, because I represented Metropolitan Community Church of Toronto, I remember Justice Bastarache, who's a very conservative judge, one of the opponents representing I think it was the Catholic churches or the evangelicals, said, well, Mr. Elliott just represents one small church. And Justice Bastarache says, I don't care how small their church is, every church in Canada gets treated equally. So I thought when I had a conservative judge taking that position, I was in pretty darn good shape. And of course, we won. The court was unanimous, and again, just like the Court of Appeal, no judge's name on it. It's the decision of all 9 judges. And as somebody who had been fighting against that idea of Christian tradition being embedded into our law, I particularly was happy to see in the ruling it said, quoting in Christendom, they said, this reflects a 19th century idea of the relationship between religion and the state that has no place in modern secular Canada. That's what I'd been waiting for all along, to hear those magic words. And so I was absolutely delighted. Of course, for my own clients, the Court of Appeal had already said that our marriages were legally valid. And so we had the right to say that the marriages performed on January 14th, 2001 were the first legal same-sex marriages in the world. We got the marriage certificates from the Government of Ontario, and I had them, a notarial copy framed and presented it to Brent Hawkes on Pride Day, certifying them to be the marriage certificates for the first legal same-sex marriages in the world. And they bear the date, that the legal date of the marriage, January 14th, 2001. A lot of people think it's the Netherlands, but their marriages didn't start taking place until April of 2001. So our marriages were first. The Dutch get credit because their government had the courage to agree with same-sex marriage first. Our government had to be dragged kicking and screaming to the Supreme Court of Canada. But once the Supreme Court of Canada had spoken, the government was in a position to act. I will say we didn't trust them. We had been suing in every province and territory of Canada and had been winning. Even the Yukon and Northwest Territory, we had. So the only ones that we didn't have were Prince Edward Island, Alberta. I don't know whether Nunavut existed at that time, I can't recall. But we didn't have, I know we didn't have Prince Edward Island and we didn't have Alberta, unsurprisingly. So when the act was introduced by Paul Martin's government, it was in some ways superfluous because we already had rulings in all of these courts. And we had got those, not so much because we didn't trust Mr. Martin, we did kind of trust Mr. Martin, but his government was very shaky, and we were afraid his government would fall and we'd have Mr. Harper. And we didn't believe Mr. Harper was going to introduce any Civil Marriage Act, even if the Supreme Court of Canada said he could. So Mr. Martin then introduced the Civil Marriage Act, and it was a very stirring moment in Canadian parliamentary history. Some of the finest speeches I've ever heard were made by the parliamentarians that day. Bill Graham's speech was excellent. Erwin Kotler's speech was excellent. And I dare say that the Prime Minister's speech was the finest one that he's ever given. It was from the heart, and it was powerful. It was a remarkable moment after all of the hateful things we've heard about gays and lesbians in the Parliament of Canada. Some terrible, terrible things have been said about us in Parliament, about how we're a threat to national security and diseased, and we prey on children and all kinds of terrible things. To hear our parliamentarians speaking about our right to equality in such stirring language was a powerful moment for me. There was some controversy about the passage of the bill because Paul Martin had used partial whip. I forget what it's called exactly, but he had insisted that the cabinet vote in favor of the bill. He had allowed his caucus members to have a free vote, but not his cabinet. And Harper denounced that, saying it wasn't a free and democratic vote, which was a bunch of nonsense, really, because most votes are not open votes. That's a very unusual thing in Canada, to allow parliamentarians to vote their conscience. And Martin took the position that this was a question of upholding the Constitution, and he wasn't going to allow his cabinet ministers to defy the Constitution. I think that was the correct position to take as Prime Minister. In fact, I think he would have been justified to expect his caucus members to take the same position, so he was already being generous, allowing them to vote against it. And some of them did. Mind you, some Conservatives voted in favor. John Baird, for example, voted in favor of same-sex marriage, perhaps unsurprisingly, but there were, and of course, the Bloc Québécois had supported it as well. They were very strongly in favor of it, and they had helped a lot with respect to making sure that that vote happened, because the government was hanging by a thread at that point, and there was a lot of political maneuvering to make sure that that vote took place, and that it was that it was that configuration of Parliament that made the decision, and not a different one as we got later with the new Harper government. So it got passed, and then this really interesting denouement, and that is, a lot of Canadians don't realize this, but of course the Governor-General signs Acts of Parliament on behalf of the Queen. But when the Governor-General is unavailable, the person who acts in place of the Governor-General is the Chief Justice of Canada. And so it was Beverley McLaughlin, as Chief Justice of Canada, acting on behalf of the Queen, who actually signed the Civil Marriage Act into law. It was a fitting moment because, of course, this entire history of same-sex marriage is really down to lawyers advocating for same-sex couples, for churches and other religious organizations that wanted same-sex marriage, and to brave judges who are willing to stand up to governments who lacked the courage to do the right thing. When this whole thing started, one of the issues was who were going to be the couples, right? There was a discussion, should it be Brent? And people said, well, what about you and Greg? You should get married, shouldn't you show that you believe in this? And we made a decision that we would not discuss it until it was all over. So the Civil Marriage Act was also important for me because I didn't feel that we could even discuss marriage until that was the law of the land. So that meant that I could then get married. And that was the happiest day of my life. It's been so important to me personally, not just because I was able to marry, and that was the happiest day of my life. It was amazing. You know, we'd been together for years, but it still was deeply touching to me to go through that and to be surrounded by your family and friends who are ecstatic. They're so happy for you. And as I said, you know, the only way you get everyone to show up like that is either to get married or to die. And so it's nice to see all those people expressing their love for you and their support for your relationship. And it really cemented for me how, you know, people had said, oh, well, marriage doesn't matter, or we've got common law recognition. It cemented for me why it was so, so important that people have that choice. I had already said philosophically, I had some feminist friends who said, why are you doing this? You know, common law is the way to go. Marriage is a patriarchal institution. And I said, well, you know what? You can choose to be in a common law relationship. I cannot. So it was important to me personally when that case ended. I said to Greg, well, I want to choose to be in a common law relationship for a while. Maybe we'll get married later, but I want to have that choice now, because I've never had that choice before. And so we did eventually marry, and I've never been happier. And I've encouraged people who've thought about it, that because I know some longtime couples who say, it doesn't make a difference. I say, oh yeah, it does. It really does. And it still has legal significance. I mean, one of the things that, the words matter. When I go around in Elliott Lake today, I talk about my husband. And you know, it's really interesting. When I was a kid, I would have been afraid for anyone to know that I was gay because the reaction would be terrible. I mean, I was threatened a number of times when I came out. I was the first openly gay person in my town. But now, when I walk around and I refer to my husband, no one bats an eye. In fact, people ask, oh, how's Greg doing? How's your husband? A happy anniversary. I see you just had your anniversary. How long have you guys been together? Oh my God, you've been together forever. It's natural for people now. They accept it. People understand marriage, and it's something that travels all over the world. When I went to Montenegro and I referred to Greg, and they were using different words in their language, and I said, no, muž, husband, that's who he is. And they were surprised, but then they started using that word because it has significance in their language as it does in every language. I was in Japan last year. Same thing, we were talking about same-sex marriage. I learned the Japanese word for marriage, and I said to the Japanese people there in their language, that is my husband. And they cheered because they don't have that yet, but they understand what it means. And don't get me wrong, I'm not just happy for me, I am, but I'm so proud of the fact that I see same-sex couples getting married. And you know, one of my cousins is a lesbian and she got married, and I was crying more than I normally would at a wedding because I know that I helped make it possible for her to be with the woman that she loves. And
as a wife.
As a wife,
yeah.
That they can, and her parents don't accept it, but I do. And I know that legally she is her wife, and I had a hand in that. And every time I see a same-sex couple getting married, I sort of stand a little taller because I know I helped make that happen. And I don't care if they don't recognize that who I am or what I did. I know that this is my legacy, that long after people forget that I ever existed, that same-sex couples will be getting married in Canada, and it will be totally normal because every time marriage has evolved to be more inclusive as an institution in Canadian history, we've never gone backwards, never, and we never will on this. We've had the most successful career as human rights activists of any group under Section 15 of the Charter. It's unbelievable the amount of change that's taken place in my lifetime to advance equality for lesbian and gay people from when I met my husband, we were criminals. Having sex with each other was a criminal act. And now we're married. And that is a revolution. And it's something I think Canadians, all Canadians, not just me, not just the people involved in the case, I think it's something that all Canadians can take pride in and should take pride in. I know we are admired around the world because of our commitment to equality, and well, we should be.